in front or before Mrs. Cronje. My Lord, a pro forma was submitted and a statement was attached to the pro forma.
Yes.
What has been canvassed to Mrs. Cronje on the statement is that the statement does not bear the signature of accused number 2.
But I recall he explained that the 3 of them signed the last page. That's how he says it was done.
That's correct, ma'am.
So he explained, unless you say that's unlawful, fine.
My Lord, the concern by the defense on the signature was the signature that was appended on the pro forma, as opposed to a signature that does not appear at the last page of the statement that is attached to the pro forma. Hence, a comparison was drawn between a statement that has been taken.
Which statement are you talking about now? The statement you showed as an example.
That's correct.
How does it assist this court? How does it assist this court? Because that statement was signed by somebody who put his thumb and what have you. It has got nothing to do with Mrs.
My Lord, maybe the court did not hear why I'm talking about that statement. I'm not relying on the statement that has been
comparing
signed
it
outside.
Wait, are you comparing it to the statement you brought?
My Lord, may I just rephrase it so that I understand myself?
Yeah, fine.
When Mrs. Cronje
was
cross-examined, she was asked to compare.
That's the point.
The statement of Colonel Rapadu and the statement that was attached in the pro forma that she conducted on
I say fine. So
yes.
What about it?
I'm saying that statement at the back of it was not signed.
Okay, fine.
That's correct.
And any other submission? Yeah, you're saying one, it wasn't signed. So I'm saying any other submission?
May I be afforded to address things according to the according to the recollection of my memory?
Okay, fine, fine.
Yes. The magistrate, Mrs. Cronje, was asked about the meaning and the interpretation of paragraph 1A of the pro forma, which she read and starts with, I'm the magistrate.
Yeah.
I'm not involved. I'm not the police office. I'm not
involved in the investigation.
In the investigations.
Yes.
Yes. Then there was, in the reading of that paragraph, there was an element of promise, which Mrs. Cronje, when she gave an answer, she told this court that that might be construed as a promise.
Yes.
And furthermore, what Mrs. Cronje has realized on the evidence when accused number 1 was brought before her, that he did not take a bath, and accused number 2 further told the court that I told the interpreter that I did not take a bath. I want to call my family. I didn't call, and I want to change the clothes. I'll submit or I'll argue later, my Lord, before my conclusion of my argument, that that was an element of torture. It's against human dignity.
So Mrs. Cronje tortured your client?
No, my Lord, I don't want to make assumptions.
But you are submitting
saying, my
that. You
lord-
say it's an element of torture.
Yes, I didn't say Mrs. Cronje tortured accused number 2.
Who was he dealing with? Was he not dealing with accused number 2 or 1, whatever?
Was dealing with accused number 2,
Right,
and accused number 2 said he did not take a
right.
bath.
And
Mrs.
you are
Cronje,
submitting that it's an element of torture.
That's my submission as
against
a
who?
defense.
Against who?
sorry,
Against who?
the state.
The state.
Against accused number 2.
That's the point.
Against number
That's
2.
how I understand it.
Yes. But that's my submission from the defense.
Yes,
When looking at the definition of what is
fine.
torture.
Okay.
The evidence of Mrs. Cronje in relation to what she has discovered after she took the alleged confession from accused number 2. She considered that accused number 2 was not brought to court within 48 hours.
She didn't say that, Mr.
We can go on record.
No. I listen. Let me tell you what she said. She says she was told that by your client that she wasn't taken to court within 48 hours. But she only had one aspect of that evidence. She didn't have a counter argument about that evidence. That's
I
what
don't-
she said.
No, I beg leave to differ with the court. That's not what the magistrate said. The magistrate said accused number 1 said he wanted to go to court.
Right?
He
Yes.
yes. But now, when she was cross-examined, it was put to her that when she was brought before her, 48 hours has lapsed. And she even said, I have discussed that with Mrs. I have seen that irregularity. And I have discussed that irregularity with Mrs. Duplessis. Then I asked her, what, as you have promised that for any irregularities that will transpire, you are going to remedy the situation. What did you do? Nothing.
Okay, you can. I'll check it, but I don't recall
Yes,
that.
please, my lord.
I can't recall it being
Yes.
that way because she said I only had one version before me. Mr. Baloi, am I correct or am I dreaming also?
Yeah, I'm just quickly checking the record. I think
You have it there.
if it's one aspect that we need to verify. My recollection was that she said that was not the issue before her, something to that effect. But
Okay, we'll check it. Fine. You can continue, Mr. Mzome Zulu. I'll check it.
Thank you, madam.
Okay. Yeah.
There's evidence by Mrs. Cronje about the appearances of those officers, that they pose a threat. They're heavily armed.
Yes. And they were doing their job. That's what they said.
Yes,
Fine.
they were doing their
And then she construes it as posing a threat. Fine. I agree.
But now, the court must assist or will assist the parties to determine on the admissibility of those
Yes, of
confessions.
course. Of course.
But now, a threat in terms of the definition of making a statement in your sound and sober senses, I'll refer the court to the definitions as they are written on my heads of argument. It also involves a form of the presence of the police. There's authority to that effect. Having fully armed, and the person who was going to take the confession, a magistrate, felt threatened. How about the person who was under arrest? That should also be considered.
Fine.
Yes. And my lord, before I get into Mjiako, I just want to get into that 2171 Roman figure 2, the one that prescribes the magistrate to take a confession. On its own, it vitiates all non-compliance with that and the irregularities that emanated during the course and the proceedings of recording such a confession. Vitiates all the elements and the prerequisites of section 217.
Okay. So she didn't comply with 217. Fine.
Thank you, my lord.
Yeah.
My lord, the court was told that there was somebody in the office, room 2, who came to act on behalf of accused number 2. And there's evidence before this court that the FFC number was recorded to prove that he was an attorney. That's not irrelevant. That's not irrelevant in terms of legal representation. The court must also consider the fact that Mjiako played a very passive role if it was Mjiako. Very passive role. My lord, is there any evidence that has been presented before this honorable court by the state through the evidence of Mrs. Cronje that Mjiako was ever communicating with the presiding officer who was taking a confession? There's no such evidence.
But look, it's a question of style. I know a judge called K. Lewis. K. Lewis would sit for 3 weeks listening to evidence and not writing anything. Just doing this. Come, you argue. After 3 weeks, you come, you make submissions, and then he adjourns for 6 hours or 2 hours or 3 hours. He delivers a judgment, just like that.
Yeah, but
Have you heard about that gentleman?
it's an individual style.
In fact, madam,
Hello?
during lunchtime, Mr. Newman was relating a similar story about a judge in Maritzburg who does the same.
Yeah, so it's a question of style. So, K. Lewis said they say he was a genius. Fine, maybe Mjiako is a genius also.
That's an
But
assumption.
I'm not saying you mustn't make that submission.
But my lord, yes, things were guided by the ethics.
Yes, fine.
Yes, that judge, I don't know how he operated, but Mjiako was guided by the ethics.
Okay.
Yes, because in terms of representing a client, we act in the best interest of a
Yes,
client.
you're right.
When Mjiako was in a passive role, who was he acting on behalf of? Who sent Mjiako there? No, let alone whether he was instructed by the family. We are concerned about the involvement of Mjiako in court. There's nothing that was said by Mjiako from when he entered that room 2 up to when he left. He never participated. Once you tender a guilty plea, I'm making an example. As an attorney or an advocate presenting a guilty plea, all the elements that are there are presented by you to the presiding officer.
Okay, I've heard you, but
Yes.
you must recall that, and I'm not saying it. Cronje says she asked Mjiako, I think she says that, if they had consulted. You remember that piece of evidence?
I can't recall that one.
Okay.
But it was,
Okay,
you can-
she said, anyway, she said she thought they had consulted.
she thought.
Yeah,
that was
because accused number 1 said, or 2, whatever, he said, this is my attorney. I want to continue with him. That's what she says. I don't know. I still have to consider that evidence, okay?
Thank you, my lord. But I wanted to draw the court's attention on the role played by Mjiako, not about what the presiding officer said. It's what Mjiako.
But you see, now you're criticizing an attorney. And I'm saying to you, it's a question of style.
Yes.
Like me, I've got my own style. There's another judge who will come here and just sit like this for 6 months. And after 6 months, write a judgment. And you have never seen those judges somewhere here. Doesn't ask any questions. You argue, you keep saying. Me, I ask questions, I want to understand. Maybe that guy is a genius. He listens to the evidence, he makes conclusions, he looks at Mr. Ramusipili's demeanor, he makes a conclusion, etc., etc. But now, you see, they are saying because Mjiako didn't do A, B, C, D, E. The question is, was Mjiako an attorney or not? Every day in these courts, clients fire advocates, clients fire attorneys because they're saying they're incompetent or they're not representing me well. It happens. But the question here is, or was Mjiako an attorney, admitted attorney, qualified to practice?
I'm making a different submission in
Okay.
relation to Mjiako because we did not challenge the credentials and his qualifications.
You did not, of course.
I did not. But
And
I
you know
put
what?
it-
You also didn't call him as a witness. You could have subpoenaed him, and you could have preferred charges of fraud against him. You could have preferred charges of professional misconduct against him.
But-
Diego was left alone.
My lord, I cannot deviate from the principle
Yeah.
that the burden is not upon
Of course, yes.
it's
Of
not
course.
upon the accused.
Yeah.
It's still with the state.
Yes, you're right.
If the state, the defense has never submitted any kind of document
That's it.
to
Yeah.
prove the existence of Mjiako to us is a fictitious somebody.
Yes, quite.
Yes.
Quite. No problem.
The state must have brought Mjiako and say, hey,
Oh,
he's lying, this man.
okay.
He paid me so much. I'm the one who did this. He said this and that. Why is Mjiako today?
No, fine. You can make
Thank you, ma'am.
we can make other submissions concerning that. No
Yes.
problem.
My lord, the letters coming from the office of Mjiako Attorneys Incorporated. If I come on record, I place myself on record, either in a civil matter through a notice of appointment as attorneys of record. Even if I withdraw, I file a notice of withdrawal as attorneys of record. But Mjiako is writing a letter to the DPP. That letter is not even directed to the court. It's directed to DPP to say, convey this message for me. That's unethical.
Miss Nchio, did you hear about it?
Yes.
She came to court and withdrew on behalf of Mjiako, according to the evidence.
I think I have to confirm that because
Now I'm telling
The
you, I was
letter, my
listening.
lord.
Nchio came personally, she's a female, and your client said, even her, I fired her, chased her away. But on record, it's, you can ask your advocate, your colleague there. It is on record that Nchio came to court and withdrew on behalf of Mjiako. That's the evidence before
My
me.
lord, the evidence, insofar as my recollection, and I'll verify that evidence, is the evidence of a lady that appeared in Tabani for accused number 2 to withdraw. as
Okay,
attorney
fine.
of record.
You remember it like that?
The withdrawal by Ms. Nchia.
Nchia,
was
yeah.
in the Tabane Magistrates
Ye-
Court.
Yes.
However,
On behalf of whom?
on behalf of accused number 2.
Are you listening to yourself?
the Tabani matter.
No, you're listening to yourself. You're saying Mchio,
Njia. Yes.
Recused herself.
She
She withdrew.
from the matter on
yeah.
behalf of Mr.
You see, you said on behalf of accused number 2. That's what you said.
That's the slip of the tongue.
Oh, I see.
On behalf of Mr. Mujia.
Okay, fine.
Yes.
All right, fine. Yes, Mr. Gomezulu.
In connection with the legal representation, I'll just conclude by saying all that was done in taking confessions or a confession in the presence of a magistrate was not done where it is required by the law or by the Constitution that the rights were explained properly to the legal representation.
So the rights were not explained.
That's my submission.
Nothing was explained according to your client. Nothing. And then, according to your client, he only had one bit of conversation with the magistrate through the interpreter to say, can you tell that lady that I haven't had a bath since the 16th and I want to go and see my child or phone my child and I want to see my parents or my sister or my girlfriend. And that was the end. That's the evidence of your client. And after that he says, ngapega pants, I looked down. Never participated in those proceedings. That's the evidence we have.
My Lord, I believe and I submit with due respect that I cannot argue that point in isolation.
Okay, of course.
Yes, because there are certain things that were not complied with by the state.
Yes, I agree.
And to single out and to be selective on could be unreasonable for accused to have performed in a particular fashion cannot be challenged on the basis that if it was his style, no one can challenge him for that. But what is very important here is whether the state
has proven
satisfied the court that he made a statement freely and
yes, of course, yes. The
the
onus is always on the state.
Yes.
Always. It never shifts.
And in State versus Yolelo, if I'm not mistaken in terms of the citation, and State versus Zoma, it also emphasizes the burden of proof.
Yeah.
Whether the accused or is lying, is misrepresenting his facts, distorting information, but ultimately the law requires the accused person to give an evidence which is both reasonably and possibly true.
Yes, that's all.
Hence, I'm saying in my submission, the evidence given by Ntanzi, to some extent, I'll discourage the fact that certain issues must be excluded as being reasonably and possibly true. I'm referring the court to the evidence of the AVL. Ntanzi informed his lawyers that this is what you must tell the witnesses.
No, fine.
When he gave evidence, recollection of the mind, the vividness of the recollection cannot be negatively attached to accused number 2 under the condition and the circumstances that he was in. He was under arrest. Firstly, Ntanzi does not reside in Katlehong, does not reside in Albertine, but he managed to secure the name that he may use at a later stage for the recollection that I was at this stage, at this time, in this place. Firstly, that what he told the court, I saw an engine garage where I saw a board Albertine. You bring the AVL. It confirms that on the 18th, a Toyota Fortuner was at Collins, between Collins and Mali, next to an engine garage. That is consistent with his version. That cannot be excluded. And number two, my lord, Ntanzi is telling this court about the dumping area. Whether the vehicle was located next to a dumping area, he is subject at that stage, under those conditions, he was capable of making a mistake. But there's one aspect that Mr. Dupree confirmed, is that a Toyota Fortuner was located driving, off-ramping from N3, joining to Mr. Mkhana. He was driving at Heidelberg Road. Talk about Market Street, New Market. I asked Mr. Dupree, can you please, the actual image, can you assist us if there is no dumping area in that Heidelberg Road? He saw, he mentioned, I can't quote it verbatim, but that's why he confirmed that he can see the municipality dumping site or something like that. Consistent with what Ntanzi was saying. And what I wish the court to consider mostly, all the evidence presented by the state is all what was happening on those days. Is that expected of Ntanzi, who had no pen and paper, to make a vivid recollection of what happened? The answer is in the negative. But what was good and brilliant about Ntanzi is to spot a particular place, where I'm going, where are they taking me to? But if I can see a word or something, I'll make sure that I'm going to use that. This is what Ntanzi has done. This is what we are busy dealing with right now. He talked about engine garage, he talked about Albertine. What is of very much importance when they collected Rapado in Cross. If Rapado, the court can decline or reject the evidence of Mr. Ntanzi to say, no. There's nothing like Chris Hani Baragwana State Hospital. The AVL confirms that the vehicle on that particular day was driving at Chris Hani Road. At, if I can remember very well, it was 1558 when, if I may put it that way, 1558, and it was regained in 1603. That is its evidence. In between, where was this vehicle? And when he put the actual image of Baragwana, after the court has canvassed the issue of a breach, it has been put by that witness during my cross-examination to say that breach is after the gates of Baragwana. It's after the gates. It cannot be said that the location was caused because that vehicle was under that bridge. If it was under that bridge from 1558 to 1603, what was it doing at that time? So the evidence or the version of Ntanzi should be accepted to be both reasonably and possibly true, because this thing comes from somebody who did not record anything from the 16th up to the 24th. He may be doubted about the evidence of Orlando, he doesn't know, but what was of importance to him to see that name Orlando. And one may assume that he was at Orlando because he assumed that he was at Albertine. I may not attach the blameworthy to accused number 2. Whether Kininda or Brigadier Kininda arrived with Sergeant Mhola in a white BMW, they may state, as these witnesses have denied, that this is the version of accused number 2 Ntanzi. Oh, I forget, there was something that also makes me to believe the evidence of Bongani Ntanzi. That they bought water. Why? Is that a coincidence? The answer is no. It's consistent with what occurred on that particular day. Water. Evidence of the AVL. I was really disappointed by the evidence of Brigadier Kininda. I can repeat it. I was really disappointed by the evidence of Brigadier Kininda. You cannot cure the damage that has been already that has already there. In relation to the date of the 24th of June 2020, white Toyota Fortune. These people were at all material time escorting. They never lost sight of the vehicle up to Boksburg. Gave that evidence. Kininda comes and say, no, accused might have confused a buggy with a canopy. This is really disappointing. And this has been confirmed that he has been transported. I even referred to Priest that what you are relying on that AVL is not consistent with that date that you mentioned, that that vehicle was in Benoni. Because this is what Jonathan has said. So the evidence of Ntanzi should be accepted as both reasonably and possibly true. Even accused number 1, he gave a very consistent evidence. The evidence of the doctor or the dentist, if Ntanzi had a gold tooth. So nothing more, nothing less. But that doctor confirmed that Ntanzi did not have a gold tooth. And during the interview on the 17th of June in Pretoria at the boardroom, they confirmed the state, Bomkhane, Mohola, whoever was there, that Ntanzi had no tattoos. Sorry, my lord, I just want to check.
I'm sorry, my lord, I was just going to my learned friend that I found the portion that the court was looking. I found the portion that the court was looking for regarding the evidence of Ms. Cronje and the 24 hours. And I was inquiring from him as when can you put this on record?
Yeah, you can put it on record. He can put it. If he agrees that that is the evidence I was referring to.
We requested it also to revisit
Of the record. Are you saying that, Mr. Baloi?
Indeed, my lord.
Okay, just tell me what is it so that when I check it,
Can I
know.
bring it on Monday? All what I can.
What is the page?
My lord, it's
Page?
the page 66.
Page 66.
Yes.
Lines?
And it's from line 10
Line 10,
and it carries on until page 67.
yes.
And the exact part that the court was referring to is on line 10,
Line 10.
line 10 to 14 on page 68.
What does the court say there?
Well, it says, Ms. Cronje says, advocate, I can only take or go based on your client's words or what your client told me that he was arrested on the 16th of June. I cannot tell as to whether he was arrested on the date on this particular matter or on another matter. I can.
Yes, Mr. Gomezul.
Thank you, my lord. Sorry, my lord, may I just consult? May I quickly approach accused number 1? My lord, before I rest on
Yes.
my submissions, I just want to make few things after consulting with accused 1 and 2. Firstly, injuries sustained by accused number 1 at the time he was taken to Mboto. It is evidence before this court that the wrists were swollen as a result of the handcuffs. Secondly, what he also informed me is the manner in which he was arrested, and it's evidenced by Constable that when he approached them, they had to apply a tactical takedown. So,
Right.
I wished the court to consider or to take it as a factor in relation to elements of inducing threat.
No. The court is
persuade.
this court is going to take everything into consideration.
Yes.
Mr. Rapi, just look at the notes I've made here, so that, yeah, can we take this? This is evidence of accused number 1 and 2. Just go through this and tell me. I read everything. Just Just go through it. Just cursory. Bheka lapho Mr. Miyeke. No, Mr. Ngumalo. That's the evidence and the cross-examination of accused number 1 and 2. It's about 5,000 pages. I've read every page there. Hello? Am I telling you the truth? Huh?
After looking at that, I've seen the highlights, the notes on the
Thank you.
pages.
Yeah, I can bring it back. I'm not the type of judge who... And I say everything I've read. It's about 30,000 pages, that evidence I've been doing. I've read everything. Okay, so are you through, Mr.
The last aspect, my lord, what is canvassed by Ntanzi, but most of the things will be also supplemented by my colleague, Mr. Ramsipil. The last part of my submission is that he indicated that about the evidence of a movement, which the court was also was concerned at the garage, at the engine garage, the movement of people.
Okay.
I wish the court to consider as well the fact that it was a COVID and movement was restricted
Yes.
to the extent that the evidence of the state might be doubtful.
Okay, no problem.
Court pleases me.
Right, is that you, Mr.? Is that your turn now?
That's correct.
Thank you. Mr. Rapid?
My lord, I thought the interpreter will interpret for the evidence of Mr. Mgomezu. Then
No,
I'll
no,
take
he's
it
going
over
to...
on Monday.
He's going to do it tomorrow, Monday.
On Monday.
Yeah.
Then, my lord, I'm going to request that we adjourn until Monday.
Why? Because of the interpretation.
No, not because of interpretation, because I need to go through what Mr. Mgomezu has gone through so that I don't repeat and burden the record with repetition of what he has said pertaining to accused 1 and 2.
You're not listening.
Yes.
You are not listening.
I wasn't listening to
What
his
Mr.
evidence.
Yeah, no.
No, to his
the argument,
submissions. I have,
the
my lord,
argument
but-
by Mr. Mgomezu.
I have listened to the
Oh, I see.
arguments,
Okay,
but
okay.
my lord, we use language differently.
Oh, I
the
see.
way we understand it.
Okay. Mr. Baloi?
We are in the hands of the defense, my lord. We're not going to...
What's the time now?
It's 10 to 3.
Okay, so let's adjourn until Monday. Mr. Miyake, will you be ready on Monday?
My lord, let me say,
What's that?
my lord, I've been working on my head as a team together with Mr. Munyeki and Mr. Ngumalo and Ms. Misholo. That's why I wanted us to sit and butt heads so that we consolidate our arguments.
Well, I've got number 5's heads of argument.
So sorry, my lord.
Accused number 5's heads of argument, I've got them.
But of Ms. Misholo, we've
Yeah.
worked together on all the arguments, my lord. We were
So are you saying,
So we wanted to butt heads because already some of the stuff, the evidence and information has been placed on record by Mr. Mgomezu. So we need to see what to isolate and
Oh,
what
okay,
to
fine.
go to.
all right, okay, let's come back on Monday, 10 o'clock.
So we are
Jen? Sorry, before I Jen.
I think it's part of Mr. Mgomezu that will make sure, my lord, that the whole judgment is given to him.
Okay, I'm giving it to you because
sorry
it's...
for that.
Judgment in case. Unfortunately, it is highlighted.
Now present the full judgment.
Sorry, you'll bring it the full judgment Monday.